Howdy, I'm attorney Rick Davis. I'm the founder of Rick Davis and Associates, a law firm in Bryan, Texas. Today I would like to talk to you about arraignments. Oftentimes, a client of mine will get a setting notice in the mail saying that his case is set for arraignment or her case is set for arraignment. Interestingly, sometimes they mispronounce it. They call it an arrangement. It's called an arraignment. Now, an arraignment is a simple hearing. It's basically an opportunity for the court to make sure that the defendant who's actually appearing in court is the same person who's named in the charging instrument. Now, the charging instrument in a felony case is usually an indictment, which is handed down by a grand jury. A charging instrument in a misdemeanor case is usually what's called an information, which is simply a sworn complaint sworn out by a prosecutor or a police officer or someone who has knowledge of the facts of the case. That's the charging instrument. So during an arraignment, the defendant is brought to court. The judge makes sure that the defendant understands what he or she is charged with, and in many cases, the the defendant has the right to have the charging instrument read to him. But in most cases, especially if there's a defense lawyer involved, the lawyer will waive the reading of the indictment or the reading of the information. So an arraignment is a simple procedural matter. It's straightforward. It's nothing to be afraid of. As long as the defendant hasn't done something to cause a new warrant to be issued for his arrest, then he or she doesn't have to worry about being able to go home at the end of the arraignment, because it's a simple routine hearing that just happens as a matter of law and is required by the Code of Criminal Procedure. So for more information, come see us at attorneyrickdavis.com.